Hey, Wes.
Let's do it.
We're gonna transfer you a call from Fulton County. I believe they want to talk to
Table. We can share it.
ASG team, before we get started, please make sure to keep an eye on your chat. Thank you.
Oh. Just 1 second. There we go. Okay. Good morning, ladies and gentlemen. My name is Judge Law, and we are going to begin with our state all-purpose calendar. This is a misdemeanor calendar with the State Court of Fulton County, in which individuals were charged with certain misdemeanor offenses. This morning, we are going to get a status of those cases and see how they are moving forward, either to take a plea or to arraign the case and further notice for trial. We are also going to be addressing a few probation matters as well as some bench warrant issues. If you're a defendant charged with one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything you say in open court, this virtual recorded proceeding that is also being live streamed, your statements can and will be used against you. You have a right to an attorney if you cannot afford one. One of our attorneys from the Public Defender's Office or the Conflict Defense List will be representing you. Who is my probation officer today? Ms. Harris? Okay. Okay, let us begin. Courtroom 2, who do we have, please?
Good morning, Judge Law. How you doing?
Well, fine, thank you. Good morning to you too.
This is going to be position number 8, Mr. Hillard.
Hillard, okay. And Mr. Howard, who is assisting you today? Or with you? I'm sorry?
McLean is assistant to that.
Oh, okay. I don't have the list where you normally give me an idea what's how the client's gonna move forward, so I'm just gonna be asking each of you, okay?
I sent it to,
Is that for
who's handling,
I sent it to you about 9, Judge.
Okay. All right. Well, I'm going blind right now, so until I print it out, how are we proceeding on position 8?
Judge, this is gonna be a not guilty, we just want to address bond. We can submit of the arraignment.
All right, this is going to be a waiver of arraignment. And Jeffrey Hillett's accused of battery and simple battery from September 8th, 2023. Mr. Hillett, you've been advised of your right to remain silent, and your attorney is Mr. Derek Howard. And let me see. Okay, when was bond set? Or was it by the warrant?
Let's see, Judge, I'm assuming it would have been at
Don't have an initial appearance unless it was the bind over. It looks like it's got $1,000 bond
right.
on the battery charge. Was the simple battery reduced, or was it a separate accusation?
Your
Looks like-
Honor,
Go
it was reduced from 23 CP 221992,
I see.
heard
I
in
see.
felony court.
Okay, so I don't have a bond on the simple battery, and the battery is $1,000. Yes, Mr. Howard?
Yes, Judge. We're asking the court to reconsider Mr. Hilliard's bond. He's been in custody 27 days in this incident. He maintains his innocence. He indicates this arose from an interaction with the complaining witness, Amanda Chenard. They had just met that day. He had an econologue room that he was renting out. He was working at the airport at the time for a company that does floor upkeep at the airport. And as a result of their interaction, he was actually injured to the point where he needed medical attention. She did not need medical attention according to the warrant, but he in fact was taken to grading. And Judge, he maintains that she was the initial aggressor in this incident. I don't know his full history, but I would ask the court to take that into account. He hasn't been able to post $1,000 bond. He's been here in Georgia for the past year and a half, where he was gainfully employed, like I said, at the airport. He's hoping that he may be able to go back to that job. He is a veteran of the U.S. Navy. He served from 2000 to 2004. And he doesn't have family here that can post bond. He indicated the bonding company told him they would need somebody to come down physically and pay the bond because he has the money, but he doesn't have any family here that will be able to post the bond. But he has been here for the last 15 months and intends on remaining here in the metro Atlanta area. He actually anticipates being able to find more permanent housing with the VA. They gave him one of those vouchers that they give. And so he's just trying to finalize, where he'll be staying. But in the meantime, he's had to pay it like the extended stay type of locations until he can find something more permanent. So Judge, we'd ask the court to convert this to a signature bond. He does have a matter in Henry County, which we believe is a mistake. He tells me that he lost his wallet at MARTA about a month or so ago. And, his ID and everything was in there. He indicates he's never been to Henry County. He doesn't know, and he indicates the officer that was arresting him was asking him questions like, do you have tattoos? And asked him about different people. He was like, no, I don't have any tattoos. And asked him about a name of someone else that he had no knowledge of. He believes someone found his ID and may have, gotten arrested and just used his name because they had his ID. But we don't believe that he is actually the person associated with that hold in Henry County. So we'd ask for a signature bond, Judge.
All right. Pretrial officer, Ms. Tyson, do we have any recent convictions or arrests for Mr. Hillett? Position number 8.
Let's see. He only has 2 arrest cycles out of Georgia. First one was in 2006, and it was out of Cobb County. He received first offender treatment. It was a felony case, and that case was sealed in 2006. His last arrest was actually in Louisiana, December 12th of 2020, and it was for disturbing the peace. And then the previous arrest was in 2019 for domestic abuse, aggravated assault. No disposition was listed for that case.
Okay.
And the GCIC does indicate a hold out of McDonough Sheriff's Office, and the warrant was signed January 25th of 2023. It looks like the underlying charge is fraud. No
Okay,
other information was provided.
thank you. Ms. Nimini, any response? Looks like his original bonds were $1,000 each on each count.
Yes, Your Honor. I just want to add that I do have a criminal damage to property in 2023 out of Fulton. So you're aware of that. So the incident happened September 8th of this year. The victim, Mrs. Amanda Trenard, met the defendant, Mr. Hillard, at the gas station the day before they arrived. They went to his hotel, which is located at the Ecno Lodge. To my understanding, they had a conversation. Ms. Trenard went into the bathroom. When she came out, the defendant was observed using a chair to block the front door. And she asked him what he was doing. And that's when he advised her that he wasn't going to let her go. And that's when she wanted to grab her personal things. And then when she tried to open the door, that's when defendant lunged at her. And she screamed loudly for help multiple times trying to defend herself. And like an officer was able to come over and observe defendant punching her. So officers also observed small lacerations to the victim, Ms. Trenard, small bruises and bumps on her face, a small bump on her face, a small laceration to her back, dark shaded bruises on her right arm, ripped pieces of her dreadlocks because he pulled her hair out. And the security officer at that location also was the one who called 911, and he saw the defendant lunge at her even after the fact, after he came into the hotel room and to try to get them apart from each other. He saw him punch her. Let me double check, that is 2 times. But yeah, he saw him lunge at her after the fact. Considering, although he has a limited criminal history, Your Honor, he is violent in nature, just based on the facts, Your Honor. So the state is asking for the 1,000 surety to stay, Your Honor.
All right, thank you. Okay, on each count, the battery and simple battery is going to be $2,500. It's going to be a $5,000 signature bond through pretrial services. He has to stay away from that, whatever that hotel is called, Econo Lodge or whatever it's called. It's at, where was that address? It's at 1360 Virginia Avenue in East Point, Georgia. He may go back one time only to retrieve his personal belongings, but he cannot return to that location after that. He is to have no contact with Amanda Sylvia Trenard. He's to stay 200 yards away from her and not communicate with her in any way, form, or manner. No illegal drugs and no weapons and no firearms. He needs to surrender any firearms that he possesses to the authorities for destruction. Within 30 days of being released, he must report to the clerk's office to let us know his new address, and we'll send him summons to come back to court.
Your Honor, may we ask that he only be released to the Henry County hold?
That's fine. They may not be able to release him anyways. So yeah, they'll have to contact Henry County and tell them to come pick him up. And then when he resolves the Henry County hold, then he'll report to pretrial.
And Judge, I would object to language saying only to the hold. They may determine he's the wrong person and lift the hold. So we're not asking that he just remain in jail.
I'm not putting the release only to the hold.
Okay, all right.
That's what the jail's going to do. The jail's going to contact Henry County. Okay, thank you. I have an inmate from Oconee County Jail. Yes, who am I speaking to, please?
Your Honor, that's going to be a negotiated plea this morning, Your Honor. Good morning.
Good morning, Mr. McLean. Is that your client at the other location?
It is. His name is Ray Shawn, spelled R-A-Y-S-H-A-W-N, Simmons, regular spelling.
Simmons.
23 on the calendar.
All right, thank you. All right, this is State versus Rashawn Jamal Simmons, accused of simple assault, case number 23 CR 2594J. Mr. Simmons, you've been advised of your right to remain silent. Your attorney is Mr. Michael McLean. Can you see Mr. McLean in courtroom 2? He's waving his hand.
Yes, ma'am.
All right. This is going to be a negotiated plea, so please raise your right hand. Do you solemnly swear and affirm your right hand? If you can.
They got me handcuffed.
I see. Okay. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Who is our prosecutor? Mr. Scirocco? Good morning.
Yes, Your Honor, Ryan Sirocco for the state.
Yes, sir. And what is the plea recommendation for Mr. Simmons?
The plea recommendation for Mr. Simmons is 12 months probation to serve 180 days in jail with credits for time served 93 days. He has been in jail with credits for time served from July 10th, 2023 to today, balance probated, 40 hours of community service, no further contact with Stephen Alexander Reed Jr., STEVEN, Alexander, traditional spelling, REID, Jr., no firearms, and a stay away from the Shell gas station at 2275 Jonesboro Road, South Fulton, along with a gun safety course. Your Honor, in this case, law enforcement arrived to the incident location, the Shell gas station.
We are stipulating.
Oh, we stipulated?
Yeah, we're
Yeah.
stipulating.
Oh, excuse me. All right, this was,
Don't mean to interrupt, sorry.
thank you very much. Does the defense stipulate to the identification, venue, and facts of this case?
We did.
All right, thank you.
For purposes of the plea, we did.
All right. Thank you, Mr. Scirocco. Mr. McLean, do you say client accept the terms and do you stipulate? You already have. Thank you. We're just making sure you do it 3 times. Okay. As I was saying, does your client agree to the terms?
He does, Your Honor. My understanding of the gun safety course is it's not terribly expensive. I don't think it doesn't go on for days and days. It's a short course.
All right. Mr. Simmons, have you consumed any medication or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
Is anyone forcing you or inducing you to take a guilty plea today?
No, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
Has it been told to you that if you enter this plea, you'll be giving up your right to a trial before a judge or a jury to be able to confront your accuser, challenge the evidence and the witnesses brought before you, present any defenses or mitigating factors if you choose to do so, and have the state try to prove the charge against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of simple assault?
Guilty.
Your sentence is 12 months to serve 180 days, credit for time served 93 days. Your time at the jail is concluded for this case. I notice you're in a different location. So as far as jail time for this case is concerned, it's over. Whenever you're released from the facility you're at, you will need to report to probation in Fulton County, and that would be at 132 Mitchell Street in downtown Atlanta. While on probation, you need to complete a gun safety course at your expense, and you must begin that class within 60 days of being released. You're also to stay 200 yards away from the Shell gas station at 2275 Jonesboro Road in South Fulton. If you return to that location, well, then you come back to jail. It's as easy as that. No further contact with Stephen Alexander Reed Jr. Just make sure you stay 200 yards away from him as well. I'm assuming he's an employee at the gas station. Mr. Scirocco?
I don't know.
That wasn't clear from the police report, Your Honor.
All right. Well, whoever you were involved with on that in that incident, please make sure you stay away from that individual. Okay, that concludes this case. Thank you.
Thank you.
Yeah.
All right. Courtroom 2.
Oh, you know what? I can't do, let me move on. You ready?
Medical is trying to connect. I don't know if they're having problems. The audio is just not connecting. So
Position 13, Mr. Jones.
Okay. Mr. Jones. I'm sorry, I can't get the document I was trying to refer to, so let's just go with Mr. Howard. How are we proceeding with Mr. Jones?
Jones is gonna be a negotiated plea, Judge.
All right. This is Jermaine Jones, accused of criminal trespass, 23 CR 5855E. Mr. Jones, you've been advised of your right to remain silent, and your attorney is Mr. Howard. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. All right, and is it?
Kalisha Body for the state. Yeah.
All right, Ms. Body, go ahead and tell me what's the plea recommendation?
Yes, the recommendation on this case is 12 months probation, served 24 days, credit for time served 12 days. It looks like his jailing began on 9/29/23, so last month. We're balance probated to a non-reporting status and stay away from 4735 State Route 138, which is the Walmart in Union City, Fulton County.
All right, thank you. Mr. Howard, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
He does, and we do, Judge.
All right, Mr. Jones, have you consumed any medicine or alcohol?
No.
All right, and have you understood everything your attorney has said to you?
Yes.
And do you understand what's going on now?
Yes.
Is anyone forcing you to take this plea today?
No.
Are you doing so freely, willingly, and knowingly?
Yes.
And has your attorney explained to you that if you decide to plead guilty to this charge, you would have to give up your right to a trial, to confront your accuser, to be able to challenge the evidence and the witnesses brought before you, and to have the state try to prove the charge against you beyond a reasonable doubt?
Yes, I understand all that.
All right. How do you plead to one count of criminal trespass?
Pleading guilty.
Your sentence is 12 months to serve 24 days, credit for time served 12 days. If you have no other holds at the jail, you should be released within 24 hours. You will technically be on non-reporting probation for the next 12 months to make sure that you stay away from the Walmart in Union City at State Route 138. I just need to check with Ms. Thomas. If he's beginning his non-reporting probation, does he still need to make a first-time report? Who's our probation officer? Ms. Harris? Oh, Ms. Thomas? Good morning, Ms. Harris. I had a question. Mr. Jones, who is in courtroom 2, is beginning on non-reporting probation. Does he still need to report the first time?
Just one time, and then we could just have him no report after that.
All right. Any objection, Mr. Howard?
So Ms. Harris, even if we send you the contact sheet and everything, would that not be sufficient for you to have what you need so that he didn't have to report at all? So I think that was it.
That's fine.
Okay, because I do have the contact sheet.
All right, Ms. Harris, just make sure you get the contact information from Mr. Derek Howard, and then we will make this as non-reporting from day 1.
Yes, I'll say, Your Honor.
Thank you.
You're welcome.
Okay, thank you, Mr. Jones. Next case, please.
Position number 11 and 12, Aretha Jones.
All right.
We're gonna need to come back to her. They did not make her available yesterday, so but I need for a breakout with her or a phone call. So we just hold that one, Judge.
All right, Mr. Howard, would you be available to speak to Ms. Jones very soon?
Yes, Judge, we just going, I guess, doing my cases now, then I can stop and speak with her and have do some.
I recommend stopping and speaking to her.
Okay, that'll be fine.
Yeah. All right. Are you going to go on a laptop?
Yes.
All right. Mr. Jordan, if you could place the medical unit and whichever laptop Mr. Howard's going to be using to speak to Miss Aretha Jones?
Yes, Judge.
All right. Francois, I'm sorry to put you out of sequence, but can we have Mr. McLean's case next?
Yes, we're good, Judge. Position 14, Mr. Martin.
Your Honor, on Mr. Daniel Martin, we have two Martins today. On Daniel Martin 14, we do need to ask the prosecutor for a resolution on all four cases. And we would need them to call us on the phone, the 2392 phone.
Your Honor, just to let you know, I received information from the clerk's office that all three of the defendant's cases, including position 14, were all announced reset for jail jury. The only case that is currently not reset for jail jury is the add-on position 1. So I'm not sure if Mr. McLean is saying he wants to pull all of them back off jail jury and resolve all of them at the same time.
Yes.
Okay.
Okay, and all right, so we're waiting on a global offer for all four cases for Daniel Martin. What about Mario Martin?
This is Mario Martin.
Oh, Mario, excuse me. Okay.
Position 15.
I see. Thank you. Mr. Sir, are you Mario Dewan Martin?
Wow.
All right. And is this going to be a negotiated plea, Mr. McLean?
It is a not guilty. We will waive the formal reading of the accusation, ask the court to briefly tell him about the maximum punishment, and we'd have a bond request.
All right. Oh, you have a bond matter as well?
We are requesting a bond reduction, yes, Your Honor.
All right. Mr. Mario Martin, this is case 20 CR 4452H. Mr. Martin, you've been advised of your right to remain silent. Your attorney is Mr. McLean. Your attorney is going to be entering a not guilty plea in essence by filing a waiver of arraignment. But at his request, I would like to also emphasize that upon your entry of a not guilty plea, your case will be scheduled for trial. At the time of the trial, the prosecutor has the complete burden to prove the charges against you beyond a reasonable doubt. If the prosecution prevails, you could be convicted of one or more of these misdemeanor offenses and be sentenced to up to a year in prison and or up to $1,000 fine for each convicted offense. The sentences could be served separately or concurrently, that is together. Given this information, how are you pleading to disorderly conduct and simple assault?
Not guilty.
All right, your case has been arraigned and is going to be further notice for jury trial. In the meantime, you do have a surety bond in place. And Mr. McLean, what is the purpose for the bond modification?
Your Honor, he cannot make his bond. He has been working as a chef for 15 years in his chef career. And he is currently working at the Ashford. He has previously worked at Bastogne and O'Sullivan's. So he's stable with his work career in the Atlanta area. He has no trouble getting work. He tells me about some of the dishes he's made. Sounds like an excellent chef. He has also in the past worked at Atkins Park. That was some years ago. They have 3 locations. Your Honor, he would like to ask the court to consider a signature bond. He has a stable address. His stable address is with his neighbors, the former neighbors, the Grants, and that's a stable mailing address, even as he today is residing in an Airbnb. So he checks with the neighbors that he formerly had on his mail because he trusts that mail.
What's the street address?
It's 2495 Hosea Williams Drive.
All right, so he doesn't live there, but his neighbors, he uses their mailbox.
Right, his former neighbors get his mail for him because at the Airbnb, he says he doesn't trust the mail where he's currently sleeping at night, where, as we use the expression, where you lay your head. So I think it was very, very conscientious of him to point out to me He says, I've got a better mailing address than that. Please don't send mail there. I don't want to miss it.
All right. Ms. Tyson, do we have a GCIC on Mr. Mario Dawan Martin, position 15?
Yes, Your Honor. It appears that this is his only arrest in Georgia, along with an FTA. And he has 6 arrest cycles out of Michigan. They're all old. Last arrest was in September of 2013.
Okay.
And that resulted in a misdemeanor conviction for domestic violence, assaulting a pregnant individual, second offense.
Okay.
Nothing to add, Your Honor.
All right. Looks like he was booked in on October 1st, 2023 on a bench warrant that was issued by Judge Taylor when he did not show up for trial on March 31st, 2022. And he's had quite a few return to sender notices. In other words, that address did not work out. And this was back in January of 2022, February of 2022, and March of 2022. So a bench warrant was issued. And so I'm not certain if this method of him securing his mail at a mailbox with his former neighbors is the best course of action. Ms. Boddy, what's the state's position on bond modification?
Concerning the bond, we're asking that the bond remain as set. This specific incident, officers responded to the area of Hackamore Drive in reference to the defendant or a male subject beating a female subject. Upon arrival, both parties were located in the roadway in a verbal altercation. Once officers made contact with the victim, Ms. Shantaria Baker, she advised them that she was at the Hackamore location when the defendant asked her to leave. As she began gathering her belongings to leave the residence, the defendant began chasing and swinging a belt at her and throwing punches at her in which she was attempting to dodge and to avoid being struck. The victim stated that she did not have a phone, and so the police call actually came from somebody else passing through who observed the altercation. When officers interacted with the defendant, they could smell a strong odor of alcohol emitted from his person, and he was very loud and belligerent even with law enforcement. In terms of the bond itself, although you heard the defendant's limited criminal history, we are concerned that this was a violent offense and that somebody else even saw that and had to call the police. So we're asking again that the bond be set, stay as preset on this case.
Okay, the bond was set as a result of a bench warrant. That's very normal where individual does not maintain a good address. And I think that was where you dropped the ball, Mr. Martin. I'm going to modify the bond to $1,500 on each count. That's going to be a $3,000 signature bond through pretrial services. We need a good mailing address. Whatever you're using ain't working.
Can I say something? Your Honor?
No, I'm not asking for an explanation. I'm just letting you know, whatever address you're using is not working. You decide whether you want to use the Hosea Williams address or whether you have a much better address. A PO box is not an address. So we'll need a good mailing address. You need to have no further contact with Shantaria Baker. Wherever she happens to be located, you have to stay 200 yards away from her and not communicate with her in any way, form, or manner. No alcohol, no illegal drugs, no weapons. You have to surrender all firearms that you may possess. Your next court date will be sent to you at whatever mailing address you provide us. I highly recommend that as soon as you release on the signature bond, you provide a good mailing address within 30 days. That's it.
Do they have a phone number?
Don't know.
No.
I need a good mailing address, phone number, email, and of course, because of this, you'll have to report to pretrial once a month. And if you don't report to pretrial, this $3,000 signature bond will be revoked and converted to a surety bond.
That's
Thank
right.
you.
I'll have him go to the clerk's office and provide all that, Your Honor. Thank you.
Thank you.
When he gets released, he's gonna have to provide something to the pretrial officer. Other than
That's
that,
right.
they're not gonna release him without any information.
We've already, no, we're not gonna go there. You're gonna provide the phone number
But have a seat.
and that address we spoke of, that's the state mailing address to pretrial services. And pretrial services will interview. Thank you. Thank you.
Thank you all.
Next case, please, Francois.
Position 16, Mr. Nixon.
This is Justice Nixon. Case number 23 CR 5666D. Mr. Nixon is accused of simple battery, simple assault, and criminal trespass from an August 16, 2023 incident. And Mr. Nixon, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. McLean, how are we proceeding in this case?
I'm not sure, Your Honor, this was not an interview yesterday. I was told that it was not set up because of a refusal. So do you want to represent yourself today? Is that the point, or did you want to speak to me? He's representing himself, as I suspected, Your Honor. I would advise against that. I'd love to speak with you about the case and explain to you what the state is trying to convey to you in the way of an offer so that you can make a better decision. But do you insist on representing yourself, or would you like to talk to me for a few minutes? Yeah, that's probably not a good decision, but Your Honor has the right to make that, and that's what I understood it to be.
All right, Mr. Nixon, my name is Judge Long. I've already made this announcement. I just want to make sure that you understand this. You have a right to an attorney if you cannot afford one. And Mr. McLean is ready, willing, and able to speak with you and explain to you your legal options and consequences from any legal decision you make. You are charged with 3 misdemeanor offenses. And please understand that if the case goes to trial and the state proves the charges against you beyond a reasonable doubt, you could be looking at a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. If you choose to waive your right to counsel, you are responsible for understanding the law, the procedures, and how it impacts the facts of your case. So you are responsible for the impact of any legal decision you make, how it may affect your freedom, how it may impact any other open cases you have, upon your residency, if applicable, upon your job, and so forth. Are you willing to waive your right to counsel, or would you like to reconsider and use the services of a highly competent attorney?
I'm confident. Am I vicarious this time?
You need to speak up.
I'm confident in my vicarious this time. Conscience was.
I didn't understand a single word you said.
Yes, ma'am. I'd like to represent your position as attorney for self.
Nope. Sit up straight and speak louder. You're competent in what?
I'm confident to represent myself.
You say the word competent and then you muffle away. So you need to speak up so I can understand what you're saying.
Yes, ma'am. I want to represent myself.
Okay, got that part. All right. What would you like to do today? How would you like to proceed? You can either plead not guilty and have the case scheduled for trial, or we can hear the prosecutor as to what they're offering you today if you want to plead guilty. What would you like to do?
I'd like to see what there's offered.
All right, Ms. Body, what's the offer for simple battery, simple assault, and criminal trespass?
Yes, Your Honor. On count 1, which I believe is the simple assault, with 12 months probation to serve 120 days, credit for time served 53, no further contact with Andrew and Emily Gianotto, and to stay away from the 1000th block of Euclid Avenue.
Euclid Avenue?
Euclid, yes, Your Honor, I apologize.
That's okay.
Along with an ADET.
All right,
As for count 2, we're looking at 120 days, credit for time served, 53. And then on count 3, we're looking at 12 months probation consecutive to the count 1.
consecutive?
Yes,
Okay, so he's going to be on 2 years of probation.
correct, Your Honor.
And let me see, it's 120 days less 53 days. And so that's about 3 or 4 more days in jail.
Correct.
Okay. All right, Mr. Nixon, that is your offer. What would you like to do?
And you spoke of the 120 days, it is concurrent, so you said 2 or 3 more days in jail. The probation is not concurrent. So I will discuss something on this soon. All right, I'll plead guilty to it.
All right, Mr. Nixon, I don't think I understood what you just said, but the probation is consecutive, so you'll be on 2 years of probation,
Okay.
less 120 days.
And then is the 120 days concurrent is what I'm saying, or is it 2 consecutive sentences?
No, that's the wrong phraseology. $120 concurrent doesn't make any sense.
They come through wrong. You see what I'm asking?
Mr. McLean is not your attorney, sir.
All right, I plead guilty, I understand.
No, you don't. Explain to me the sentence. How would you be serving the sentence?
And you said it's 2 years for probation, correction, 2 years probation, right, concurrent. And that you said, what I'm saying with the 220 day sentence out of Ramsman Securus or whatever it is. Are you running them CCR alongside each other? As far as 120 days, I'm willing to plead to 1 misdemeanor, basically.
No. They're making an offer for all 3 counts, and you'll be on probation for 24 months, less 3 months. And you'll have to report every month. You need to stay away from Euclid Avenue. You need to do an alcohol and drug evaluation, and you need to stay away from Emily. They're not agreeing to let you plead to just 1 charge. All right, I can reset your case for you to get paperwork to review, and I can see you on Thursday. And that will not prejudice your case because you will have additional 4 days to serve at jail.
I said it for that first round.
I've already repeated myself. I'm not going to repeat myself again.
Thank you, man.
Thank you. We're going to reset Mr. Mr. Chastis Nixon to Thursday at 9 a.m. We highly recommended that you speak to an attorney.
This case. This is gonna be position 17, Mr. Penna.
Okay. Mr. Jordan, I don't know what's wrong. Is it October 12th, Thursday, October 12th?
Yes,
All right,
October
thank you.
12th.
Thank you. 17 is Mr. Jorge Pena Elizondo, accused of criminal trespass from September 21st, 2023, accusation number 23 CR 5856A. And Mr. Pena, I don't mean to be rude, but do you speak and understand English?
Yes.
Okay. And Mr. McLean, how will we be proceeding?
Negotiated plea, Your Honor. The stay away address is known to him. He understands where to stay away from. This is a non-reporting probation recommendation, so that is appreciated.
All right. Mr. Pena, you have a right to remain silent, as I've explained, and your attorney is Mr. Mike McLean. And this is going to be a negotiated plea for non-reporting probation and a stay away. All right, he's distracted right now. Whenever he's ready.
Your Honor, could we have just a moment?
Sure, you might want to mute your mic.
I'd like to mute for a moment and give.
All right. Oh, Okay, let's start now.
You okay?
Are we ready to proceed?
We are.
All right. As I was saying, Mr. Pena, this is going to be a negotiated plea. I'll need to place you under oath. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Body, what's the plea offer?
Yes, Your Honor. Does the defense stipulate to the venue ID and facts?
We do.
The recommendation is going to be 12 months probation, serve 24 days, credit for time served 12 days, balance probated to a non-reporting status, and to stay away from 1105A Holcomb Bridge Road, which is the Exxon located at that address.
Right. Thank you. Mr. McLean, does your client have the probation information filled out already for contact and so forth?
I believe that we have a form for that, Your Honor, and I'll have him fill it out.
All right, that needs to be completed in order for him to maintain the non-reporting from day one.
Very good. Thank you.
All right. Mr. Pena, have you consumed any medication or alcohol?
No.
And have you understood the proceedings so far?
Yes.
Are you satisfied with your attorney?
Yes.
Is anyone forcing you or inducing you to plead guilty today?
No.
Are you prepared to waive your right to a trial, to confront your accuser, to be able to challenge the evidence and the witnesses brought before you, and to have the state try to prove the charge against you beyond a reasonable doubt? Are you prepared to give up these rights?
I mean, yes, yes.
I didn't understand that response.
Yes, Your Honor, yes.
How do you plead to one count of criminal trespass at the Exxon gas station at Holcomb Bridge Road?
Guilty.
Your sentence is 12 months to serve 24 days, credit for time served 12 days. If you have no other cases holding you at the jail, you'll be released within 24 hours. Right now, from this point onwards, you are technically on non-reporting probation, provided that our probation officer gets all your contact information. If the contact information is not sufficient, you will have to report to probation the first time at 132 Mitchell Street in downtown Atlanta. After that, your probation will be non-reporting. This simply means that if you get arrested or if you get in trouble with the law or if you violate the conditions, your probation can be revoked and you can serve out the rest of the year in jail. The condition is that you have to stay 200 yards away from the Exxon gas station at 1105A Holcomb Bridge Road. Thank you.
Have him wait. I need to explain to him. We'll wait. Okay, now. Let me explain to him now. I've got to. Okay.
All right. I have two individuals. I'm going to go with medical first. Mr. Howard. Who did you have?
11 and 12, Ms. Jones.
I can handle her while she's seated there. What's her name?
This is Ms. Jones, Judge. The lady who was on the camera earlier was not Mrs. Jones, so this is the correct Mrs. Jones.
All right. And
Yeah.
that's the client with whom you've been conferring?
Yes,
Okay. Are we ready to proceed?
we are, Judge.
All right. This is Arethea Raquel Jones. She's got two cases with us. One is a bench warrant. First case is 21 CR 3306D, in which she was accused of battery causing substantial physical harm from March 17, 2020. The second case is a bench warrant 23 FTA 860. Ms. Jones, you have a right to remain silent. Anything you say in open court about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. Derek Howard. How are we proceeding, Mr. Howard?
Judge, this is going to be a not guilty, and we'd like to readdress bond.
All right. Are you filing a waiver of arraignment or?
Yes, Judge, I can file a waiver of arraignment for her.
All right. Ms. Jones, your attorney is going to be entering a not guilty plea on your behalf for both cases, and the cases are going to be scheduled for trial. Your attorney is going to ask for a bond modification. Please proceed, Mr. Howard.
Judge, for clarification, you indicated there were two cases.
Well, the second one's a bench warrant, so.
Okay, all right.
Go ahead.
Okay, that would just be okay, so the 22 CR is all right, I'll file a waiver on that one. And so Judge, Ms. Jones has been in custody 15 days. She indicates that the address that I was showing up until September 26th of this year, it was a 2900 Landrum address, was her current address back when she missed court in October of 2022. She indicates she was pregnant at the time. She said she did not get a notice, or if she would have shown up to court or certainly would have addressed it. She was on.
I'm sorry, which one was it? She didn't receive notice because she was pregnant, or?
Well, no, she said, no, I didn't say because she was pregnant. I just said she was pregnant at the time. And she said she did not receive notice, which is why she didn't respond to court in October of 2022. But she just said she didn't get notice. She did recently change her address. But at the time that she missed court in October 22, she doesn't understand why she didn't get the notice, but she had no intent to abscond or not show up to court. I don't know if her history indicates that she has had a history of that, but I can tell you in this instance, she claims that the alleged victim, Miss Innocent Bigby, was actually the initial aggressor in this case. And they, after Miss Bigby attacked her, she indicates she defended herself. And then there were other friends of Miss Bigby that were on scene that jumped her, and her booking photo shows she was quite swollen when she got arrested back in when this was, that she suffered injuries as a result of the attack back in 2020. And she definitely wants to contest these charges. So we're asking the court to set aside the FTA. She's just a $2,000 FTA where she's being held on in connection with this. If she does not have a history of FTAs, we'd ask the court to consider that. She does have another matter that she'll have to resolve before she's released. But as it relates to this charge, we would ask the court to consider setting that aside.
All right. Ms. Bodie, I'm actually going to go straight to you. Any objection to amending the good bond to a signature bond?
Yes, Your Honor. It looks like she's also in jail on a second FTA, case number 23 SC 18596B. So as it relates to that, the state would ask that the bond remain as set, as she does have not only one instance of failing to appear, but two, and another open case in which she has to resolve here as well.
All right.
And Judge, I would just add the same address, obviously, is for both cases. And I don't know what the problem was with the Landrum address, but she just indicates she didn't get notice. So both of these cases have an FT on it. But prior to that, I don't believe she has a history outside of it. And Judge, I would like to make the court aware she does have 3 minor children, ages 14, 13, and 10 months that she's are with family right now. She's obviously concerned about being able to care for them. She does work full-time at the Doubletree and Hilton Inn over on Virginia Avenue as a housekeeper. So she certainly wants to be able to keep her job to maintain employment. She does have a court date next week on the Superior Court charge next Tuesday. So she's hoping that she'll be able to get a reasonable bond in that case so that she can potentially get out of jail. So we would ask the court to consider, setting aside this particular bench warrant.
Ms. Jones, for the battery case, this was a charge from March of 2020. You got a signature bond, you were released, and we had an address. 1 year later, you got arrested for burglary, and you were back in Fulton County Jail. And we still have the Landrum address. And then you did not show up in court on October 7th of 2020, and a bench warrant was issued. And I'm assuming a bench warrant was issued in the felony burglary case as well. I'm not buying that you did not receive notice. I absolutely do not believe it. All right. Not a single case has got a return to sender. What I do believe is that you moved and you did not let us know your new address. That's what I believe. All right. And if you want to spend more time at the Fulton County Jail, then the easiest thing to do is not comply with any of your conditions of your bond. Because if you don't comply, the only recourse we have is to invite you back to jail with a warrant where you can enjoy our luxury surroundings. Do you understand? I am not buying at all that you did not get notice. On the battery substantial physical harm, your bond's going to be $5,000. It's going to be a signature bond through pretrial. You're going to make sure we have your correct mailing address. You're going to report to pretrial once a month, just to make sure that you are staying out of trouble and that you have provided us with the correct information. And you're going to show up for court every time you are summoned. And if you don't know what your court date is, and if you're having problems with your mail, you need to contact the public defender's office and check maybe once every 2 weeks whether you have a court date coming up. Because clearly, you and the mail don't get along. No further contact with, I can't pronounce this person's name. I think it's Innocent, but it's INNA, Innocent Bigby, and to stay away from 4555 Washington Road in Atlanta.
Your Honor, if I may, I don't believe I placed the recommendation on the record, but I can do that. But we also, the state would like to withdraw that recommendation now that she decided to plead not guilty.
Okay.
And move forward. So the recommendation for the battery substantial physical harm will be 12 months probation, served 30 days in jail, credit for time served 15 days, balance probated, and to stay away from 4555 Washington Road, apartment 27C. Again, no further contact with the victim, Innocent Bigby, and a 12-week anger management course. And like I said, that offer has now been withdrawn.
All right, noted. Thank you. All right, Mr. Howard. Thank you, medical. We concluded with Ms. Jones. Do we have somebody else at medical?
And so, Judge, that would be a 5,000 SOB through pretrial on 11, and then
Pretrial,
set aside on set aside on position 12.
Yeah, set aside the bench warrant.
All right.
Well, I can't set it aside. It's just been closed out by the arrest. So
Judge, actually, the way it's because of these charges, that was the case before, Judge, but now because there's a separate failure to appear, a fingerprintable charge, it'll
okay.
just hang out there unless we do the set aside.
All right. Yeah, the damage is done. She was already arrested, so we can set it aside. Thank you. All right. We have Norman Gibson. I don't know if that's the name of the phone holder or the name of the individual at that Zoom panel. ACDC, I'll be with you shortly. Francois, I'm going to this separate location. Is that okay? Courtroom 2? Okay. The phone with Norman Gibson. Who is that?
The South Annex.
Oh, South Annex. Okay. And is the defendant's name Norman Gibson?
No, Redding.
What's your Charles Ray?
Charles Redding, R-E-D-I-N-G, Redding. Charles
Redding. Okay.
Judge, he's on the probation calendar, and actually, if I could just do a breakout with Mr. Redding, yes, he's on the probation calendar.
Okay.
All
Mr. Redding, Mr. Derek Howard is going to be speaking with you. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you, and your counsel is Mr. Derek Howard. Mr. Jordan, if you could place Mr. Redding at the Norman Gibson panel with Mr. Derek Howard. Thank you.
No problem, Judge.
All right, ACDC, I see two women there. Good morning. My name is Judge Long, and I just want to remind you that these are active cases against you. You have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and one of our public defense counsel will be representing you. Deputy Milton, good morning.
Morning, Your Honor.
Which one is represented by Mr. McLean?
Your Honor.
Yes, Mr. McLean?
Sanders is represented by me for a plea. Ms. Walker is going to need a social worker visit.
All right. I think I have Miss Sanders, Kendra Sanders. Is that your name, dear?
Yes, ma'am.
Okay. This is position 20, case number 23 CR 5929J. She was accused of driving while license suspended or revoked from September 30th, 2023. And Ms. Sanders, you've been advised of your right to remain silent. Your attorney is Mr. McLean. How are we proceeding, Mr. McLean?
No, that's a plea. There will be $1,000 fine. I asked her to decide whether to ask the court for 100 hours of community service in its stead. Did you decide that, Ms. Sanders, on what to ask?
I'm on probation with another county. I don't know how to juggle it, but I'm gonna try to pay it. Do I have the 12 months to pay the $1,000
The fine should normally be paid within the first half of a probation period, and you can get off your probation the quicker you pay the fine. Normally.
Okay. I'm gonna try to pay the fine.
Okay, we'll stick with it as stated, Your Honor. Thank you.
Let's not forget also pleading guilty to driving while license suspended will trigger a license suspension, so she won't be able to drive for the next 6 to 7 months, depending on when the suspension kicks in.
We discussed that yesterday, and she is aware of that.
Okay, thank you. Ms. Sanders, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Scirocco, yes, sir. What's your plea offer?
Yes, Your Honor, the state's plea offer in this case is 12 months probation to serve 15 days. Credit for time served 8 days from October 3rd of this year onward, a balance probated with a $1,000 fine, as well as a 6-month license suspension.
All right. Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do.
All right. Ms. Sanders, does anyone, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Is anyone forcing you, inducing you to take this plea today?
No, ma'am.
And are you satisfied with your attorney services?
Yes, ma'am.
If you decide to enter this plea, you will give up your right to challenge this charge in a court of law before a judge or a jury. You will not be able to confront your accuser, challenge the evidence and witnesses brought before you, as well as have the state try to prove the case against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of driving while license suspended or revoked?
Yes, ma'am.
How do you plead, Ms.
Oh,
Sanders?
I'm sorry. Guilty. Yes, ma'am. Guilty.
Your sentence is 12 months to serve 15 days, credit for time served 8 days. The remainder of the time you'll be on probation at the Fulton County office, which is located at 132 Mitchell Street in downtown Atlanta. If you have no other holds, you'll report to probation next Thursday before 3 p.m. at that location. While on probation, you will pay the $1,000 fine. Keep in mind that your license will be suspended for the next 6 months, and the suspension will begin upon notice from DPS, and then it will be suspended for a total of 6 months, after which you can apply for reinstatement. Any questions?
No, ma'am.
All right. Don't forget to pay off your $1,000 fine too. Thank you.
All right. Thank you.
Courtroom 2, who do we have?
Position number 21 and 22.
Okay.
That's Mr.
And-
William Sanvey, Your Honor.
Okay, and Mr. McLean, you said that someone at ACDC needs to see a social worker. So are we resetting that case?
Yes, Your Honor, that would be Deneen Walker,
Ms. Walker at ACDC?
number 27.
Your Honor, she refused to come out.
Okay, please, and so are we resetting it to next Tuesday?
Yes, Your Honor, that would be fine.
All right. Deputy Milton, her case is going to be reset to October 17th, pending a social worker evaluation. All right.
Okay.
Thank you. William Sandber is position 21 and 22. 21 is case number 22 CR 8114F, in which he's accused of simple assault from December 1st, 2022. The second case is 23 FTA 845. This is a bench warrant that was issued, for failure to appear on September 7th, 2023. Mr. Sandberg, you've been advised of your right to remain silent. Your attorney is Mr. McLean. And Mr. McLean, how are we proceeding?
Not guilty, bond is moot at this time, Your Honor. We would ask the court to simply tell him of the maximum punishment possible, but I have advised him of that myself. But I'd like to waive the formal reading of the accusation.
All right. Mr. Sandberg, your attorney is going to be filing a not guilty plea on your behalf. Your cases are going to be further noticed for trial. At the time of the trial, the prosecution has the complete burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the prosecution prevails, you could be convicted of the simple assault and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead? Mr. Sandberg, given this information, how do you plead?
I concur with my attorney, Your Honor.
I'm going to ask you a third time and find
Not
out.
guilty.
Thank you.
Your Honor,
Yes, Mr. Skura.
at this time, the state would like to withdraw its plea recommendation as well as state it for the court.
You may proceed.
The recommendation was 12 months probation to serve 90 days in jail, credit for time served 22 days from September 22nd onward, balance probated, 40 hours of community service, the Family Violence Intervention Program, no further contact with Danielle Sanvey, Danielle Sanvey, Sanvee, and a stay away from 4734 Campbellton Road Southwest, as well as no firearms.
You know, we do already explain to our clients that unaccepted offers are no longer assumed to be offers. That's routine for us. Thank you.
So noted. Thank you. Next case, please, I'm going back to ACDC. Who's the next person, Deputy Milton?
Position 7, I'm not sure who's her attorney. Tatiana Ferris.
Oh, that would be Derek Howard.
Okay, what about?
Oh, he's available. I think so. Mr. Howard, are you ready to address position 7, Tatiana Ferris?
Yes, Judge, I just need to get to my paperwork. Let me see.
All right.
Yes,
Ms.
Judge.
Tatiana Ferris is accused of obstruction of a law enforcement officer in case 21 CR 6633B. And this is from a November 28, 2020 incident. Ms. Ferris, you've been advised of your right to remain silent, and your attorney is Mr. Derek Howard. How are we proceeding, Mr. Howard?
Judge, let me see, Ms. Ferris, not talk.
She's been offered a
That's right.
time served.
And actually, Judge, I'm waiting to hear back some information before we do the plea. Is there any way we can come back to her? I'm reaching out to us, trying to get a response from her Superior Court attorney. Is she the last one over at ACDC? Can we do the other females?
Let me see. You have another client there. Ms. Ferris, your attorney is still waiting on some information. We will take you up shortly.
Okay.
Deputy Milton, who's the next one?
Position 9, Ms. Johnson.
Okay. This is State versus Sharon Johnson, accused of simple assault, family violence from June 12, 2020, case number 20 CR 4844C. And Ms. Johnson, you've also been advised of your right to remain silent. Your attorney is Mr. Derek Howard. And Mr. Howard, how are we proceeding on Ms. Sharon?
Will be no processing the.
Oh, I'm sorry, Ms. Nimini.
Position 9 and 10.
All right.
Thank you, Madam Prosecutor.
Ms. Johnson, the state has decided not to pursue a prosecution with regards to the simple assault and the bench warrant. So your cases are closed out. If you have no other holds at the jail, you should be released within 24 hours.
Thank you.
All right, thank you. All right, that just leaves Miss Tatiana. As soon as Mr. Howard, you get the information, we'll come back to her. Not yet, Miss Tatiana. Thank you.
Your Honor,
Yes,
when we finish with Ms. Ms. Ferris, I'm gonna go and get Ms. Brown and Mr. Salazar.
at ACDC?
Yes, Your Honor.
Okay, I guess they'll give Mr. Howard enough time to get some information back. Thank you. Back to courtroom 2. Mr. McLean, who do we have with you?
Your Honor, I just want to put on record that the state is no crossing position 9 and 10, considering that the victim is deceased.
9 and 10, that's
Ms. Johnson.
understood. Thank you. All right, the reason for the null cross, understood. Thank you. Sorry about that, Mr. McLean. Oh, who's your client next to you?
Position number 3 and 5.
Okay. Is that Mr. Howard's client?
Yes.
Mr. Butts, that would be 3, 4, 5.
All right, I don't know where Mr. Howard is.
He's right there. So there he is on the, there he is.
Okay. Mr. Howard, are you prepared to address Brian Butts, position 3, 4, and 5? He's in courtroom 2.
I am, Judge, and I'm gonna walk back over.
All right,
All right, so I'll be there in 2 seconds.
all right. And who is at 3 South?
This is Mr. Martin. It's our position number 14 and position add-on number 1.
Is that your client, Mr. McLean?
I'll be about that on the phone, I'm sure. But,
This is Daniel Martin.
right. That's number 14, and the state's going to be calling me on the 2392 phone.
Okay. Mr. Daniel Martin, your attorney is still waiting for information from the prosecutor, so I don't know who it is. Is it Miss?
Your Honor, I sent the global recommendation to Mr. McLean.
Did you
Gosh,
put it in the chat or in the email or?
I did put it in an email. If I need to put it in the chat, I can as well, but I sent it at 9:44 about 30 minutes ago.
Okay, I think he was expecting a phone call, so.
Okay, so if he will put his number in the chat, I will give him a call and convey the recommendation verbally.
It's okay. Loud. It's 404-612-2392.
Okay, thank you.
Yeah.
All right, Mr. Howard, we have Brian Butts case and his. These are 3 cases. Each case is one in which he's accused of criminal trespass. The first one is 235901C from June 15, 2023. The second one is 23 CR 5902C from July 18, 2023. And the third one is 23 CR 5903C from June 18, 2023. 2 in June, 1 in July. Okay. And Mr. Butts, you have a right to remain silent as previously explained, and your attorney is Mr. Derek Howard. Mr. Howard, how are we proceeding on all 3 cases?
This will be a negotiated plea.
It's a negotiated plea, okay? And Mr. Butts, please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Thank you. Ms. Nemini, what is the offer for each or all 3 cases?
Yes, Your Honor. The state's offer is 12 months to serve 22 days, credit for time served 12 days, balance probated, non-reporting, stay away from the Chevron Food Mart at 5851 Buffington Road, Union City for a position 4. The same offer, and I think it's the same location as well, 5851 Buffington Road, Union City. And then for position 5, 12 months to serve, 12 months served 22 days, credit for time served 12 days, balance probated, non-reporting, and a stay away from the Dollar General located at 3300 Royal South Parkway, South Fulton. And defendant stipulates the venue, ID, and
Actual basis?
Yes, Your Honor.
We do that. We do stipulate.
Mr. Howard, does your client, has he filled out the probation contact information with email, cell phone number, phone number?
It does,
Any kind, all the requisite contact information they have in those forms?
and does, with his case, that is the challenge, is the contact information is limited, non-existent.
Next of kin, church, current housing?
Yeah, we did talk about that, Judge. Unfortunately, we don't have that, which is why in this case, if that's required, we would ask it to be balance suspended if the court would, I mean, if the state would be agreeable to amending that. It's just not a way we're gonna be able to contact him for purposes of having him to report or to even check in at this point. He's unstable to that degree.
Ms. Nemini, is the state willing to move forward with non-reporting probation, keeping in mind that probation has no way of reaching out to this individual? Other than if he gets arrested again?
Your Honor, I'm gonna have to confer with Miss Falk,
I think Ms. Falk's on the phone with
and that is a no.
Okay, got it. All right, Mr. Howard, your client will need to give him some kind of contact information for me to put in a non-reporting probation.
What am
And the alternative is balance suspended. Ms. Nemini?
The state is going to stay at the balance probated, Your Honor.
All right, I can kick this as a non-negotiated plea, Mr. Mr. Howard, if we want to proceed, because we really cannot have dead time during this proceedings.
I apologize, Judge. I was trying to, because we went over tried to get information yesterday, and we weren't able to get anything, but he is, we may have a number that we can use. He's his father. He did give me a number, so I'll give it, I put that number on the JCS.
Okay.
Your Honor,
Yeah,
the state. Never mind.
So yeah, we'll,
I'll take a phone number and we can give it to probation, and if he's MIA, then I guess if he gets arrested, probation may be revoked, as long as he understands that.
right, Judge. Since it's non-reporting, right, that would be the only reason for him to have contact anyways, if he were to violate and get arrested.
Correct. Okay, let's proceed. Mr. Howard, with that contact information, I'll ask Mr. Butts his questions.
Okay.
Mr. Butts, have you consumed any medication or alcohol recently?
Judge, go ahead and respond. No.
What was that answer?
No.
And have anyone forced you, induced you to take a plea today? Has anybody forced you to plead guilty today?
Yesterday, he told me, he talked to me yesterday and said, told me to plead guilty.
Well, are you doing so on your own decision, or are you being forced to do so?
I'm doing it on my own decision.
Okay, are you satisfied with your attorney?
Yeah.
And has it been explained to you that if you plead guilty to these 3 criminal trespass cases, that you will be giving up your right to go back to court and have a trial? You will not be able to face a judge or a jury. You will not be able to confront your accuser. You cannot challenge the evidence and the witnesses brought before you. And you will not be able to have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
About those rights yesterday. Remember those rights we talked about yesterday? Yeah.
Are you prepared to give up the rights?
Rights for what? The constitutional rights we went over yesterday, and she just went over. Are you prepared to get those up? Like we talked about yesterday, giving up those rights to go to trial and do all of that. So it's like,
We can talk about, it don't make sense.
All right. I can reset the case next week so that he can try to understand what's going on.
you can't judge. We went over a few times yesterday, but if he wants, yeah, right, we can take more time on it. So we can.
All right, we'll have to come back to him until he understands.
Yes, I understand. So yeah, we'll come back. We can reset it. Will you
Reset
go
it?
Thursday, Judge, or? next-
Thursday is fine.
Yeah, we can do it for Thursday.
Position 3, 4, and 5 are reset to October 12th.
All right, so we'll talk again, all right? We'll come back and see. More about it. All right.
All right, the
Well,
state, yes,
I'm sorry, Judge, I have position number 11 and 12. I mean, 12 and 13,
11, I'm sorry.
probation.
Remember, we need to break out. Remember? So Judge, if we can put me in a breakout with 3 South and go on to someone else.
All right, 3 South, Mr. Howard needs to talk to his client, so we'll be with you shortly. Who do we have seated next to you, Mr. Howard?
Got position 25.
That's Mr. McLean.
25.
All right, and Mr.
Excuse me,
Howard.
Judge.
Yeah, just one
So I
second.
need to put Mr. Howard and 3 South in a breakout?
Yes, Mr. Howard's going
Okay.
back to his laptop, and then both of them need to be in a breakout. And then I think he needs to talk to the Zoom panel also at Norman Gibson. You have 2 clients on Zoom waiting to speak to you, Mr. Howard.
I've spoken with Mr. Reddy, who's on Gibson, and actually is Ms. Harris. If she could call me at 2392, actually briefly, because I've already spoken with Mr. Reddy and I need to talk with her briefly about the other issue. So if she could call 2392, Ms. Harris.
Ms. Harris? Ms. Probation Officer Harris, could you please call the jail at 404-612-2392? And Mr. McLean, your client is Jonathan Smith, would that be correct?
I'm sorry, Your Honor. Could you say
Your
that?
client seated next to you is Jonathan Smith,
Correct, Your Honor. That's number
25.
5.
Okay. This is State versus Jonathan DeAndre Smith, 23 CR 5857E. Mr. Smith, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. You've been accused of theft of services on September 4th, 2023. How are we proceeding, Mr. McLean?
Your Honor, this is a negotiated plea of guilty.
All right. Mr. Smith, please raise your right hand. For purposes of the plea, I need to place you under oath. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. How would you like to be addressed, as Mr. or Miss Smith? I can't tell from the Zoom.
Mr. is fine.
All right, thank you. And Mr. Scirocco, what is the the plea recommendation?
Yes, Your Honor, the plea recommendation is 12 months probation to serve 20 days. Credit for time served 12 days from September 29th onward, balance probated, as well as an anti-theft course, a stay away from the IHOP at 6902 Londonderry Way, Union City. And we are asking the defense to stipulate to identification, venue, and factual basis.
Mr. McLean, does your client accept these terms and do you so stipulate?
We do stipulate, and he does accept the terms, Your Honor.
All right. Mr. Smith, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes,
Are you satisfied with your attorney?
yes, ma'am.
And is anyone forcing you or inducing you to take a plea today?
No, ma'am.
If you decide to accept the recommendation to enter a guilty plea, you would have to give up your constitutional right to a trial, to confront your accuser, to be able to challenge the evidence the witnesses brought before you, present any defenses if you choose to do so, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of theft of services?
Guilty?
Your sentence is 12 months to serve 20 days, credit for time served 12 days. Your jail time is concluded. You'll be on probation to complete an anti-theft class. And then after which, if you complete your anti-theft class, any objection to non-reporting, Mr. Scirocco?
No, Your Honor.
All right. If you finish your anti-theft class, then your probation will be non-reporting. So the sooner you're done, the sooner your probation will be non-reporting. Whether you're on active or non-reporting probation, you must stay away from the IHOP at 6902 Londonderry Way in Union City.
Yes, ma'am. Thank you so much.
You're welcome. Thank you. You know, I haven't been to an IHOP in years. They still do those German pancakes? Okay.
They do.
All right. Okay. Next one. They still do whipped cream on everything?
If you want it.
Oh. All right. Are we ready for any of Mr. McLean's cases at ACDC?
Excuse me, Judge Law, I guess the group was kicked out the breakout session and Derek was not there.
Yeah, I'm Ms. Harris hasn't called me. I need her to call me.
Okay,
Is she on the Zoom?
Probation
Yes, I am.
Officer Harris,
Number to the jail?
404-612-2392.
239. Okay, thanks, Sean. I'm calling right now.
Okay. Mr. McLean, the young lady at ACDC, is that your client?
No, she's mine.
Janine Walker is, but not this person, Your Honor.
That's
All right.
Mr. Howard.
Mr. Howard, what's your client's name?
This is Marquita Brown.
That's Ms. Brown, Judge.
All right.
But Ms. Harris is calling me, so can I take that call?
Yeah, okay, go ahead, but mute your call, please.
All right.
Mute your Zoom. Thank you. Ms. Brown, we're going to be with you shortly. As soon as your attorney is available. Okay, Mr. McLean, do you have any other clients in courtroom 2?
I do not.
All right. So Mr. Howard has Ms. Brown at ACDC, Mr. Reddick at Norman Gibson, and the gentleman at 3 South.
And we have Ms. Ferris also, Your Honor.
Mr. McLean, do you represent Ms. Ferris?
No, Your Honor, that's number 7. That's Mr. Howard's as well.
Okay.
We have
So-
position number 26, Mr. Thompson.
Have a seat right there.
26, Mr. Thompson.
Just sit right there until you're ready.
26 is a plea, Your Honor. That's time served, 1 count. It's 10 years old.
Where is Mr. Thompson? Is he at 3 South?
5 North.
5 North, ma'am.
Okay, let me get to that panel. I'm sorry. It's on a separate page. Okay, got it. Thank you. All right, Mr. McLean, are we ready to proceed with your client, Jeremy Thompson?
26, yes, Your Honor, we are.
All right, this is Jeremy Thompson, 14 CR 010625, accused of theft by shoplifting from June 2nd, 2013. Mr. Thompson, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. That's correct. This is a charge from more than 10 years ago. And Mr. Scirocco, how are we proceeding?
Yes, Your Honor, the defense is requesting time served 37 days. The defendant has credit for time served from September 4th to today. Does the defense stipulate to the identification, venue, and facts?
We do.
All right. And if we can unmute 5 North, please. Mr. Thompson, please raise your right hand. Do you solemnly swear that information you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right, sir. Have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood the proceedings?
Yes, Your Honor.
And are you satisfied with your attorney?
Yes, Your Honor.
And has it been explained to you that despite the age of the case, that you would be giving up your constitutional right to challenge this case in a court of law, in a trial? You won't be able to confront your accuser, challenge the evidence and the witnesses brought before you, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
And you understand that if you have a theft by shoplifting conviction on your record, a 4th arrest for such an offense will automatically be a felony. Has that been explained to you?
Yes, Your Honor.
All right. How do you plead to 1 count of theft by shoplifting?
Guilty, Your Honor.
Your sentence is 12 months to serve 37 days, credit for time served 37 days, balance suspended.
Thank you.
Thank you, sir. All right. I think we are waiting on Mr. Howard to address the other cases. So I'm just going to go down. Is Mr. McLean available?
I am, Your Honor. Let's see if we have anything left.
Okay, let's see. Position number 1, Edward Bailey. What's the announcement?
Well, 1 through 13 is Mr. Howard.
Oh, I see. I'm so sorry.
We have position of probation 4 and 5.
4 and 5. Is that Mr. McLean or Mr. Howard?
What's the name on 4 and 5?
O'Neill.
O'Neill.
I believe O'Neill is going to be a recommendation of time served. Is that correct?
Are you prepared to take it, Mr. McLean?
We are.
Okay.
We are, Your Honor, yes.
Okay. Yeah, I'm just trying to. I don't see an O'Neill on.
It's a probation.
Could you give me the full name?
Durante O'Neill. Deronta. Last name O'Neill. Like Shaquille O'Neal.
It's positions 4 and 5 on the probation calendar, Your Honor.
Oh, I'm sorry. I reverted to the Thursday calendar. Sorry, force of habit. Sorry.
So 4 and 5 on the regular would be Mr. Butts.
I got worried. I was like, why is my probation calendar so long? Okay. All right. This is State versus Durante. Just 1 second. Is my probation officer away from Mr. Howard? There she is. Ms. Harris, are we ready?
Yes, Your Honor. Which position is this?
This is position 4 and 5, Durante O'Neill. He is located at the 5 North location.
Okay, yes.
Okay. This is probation matters 22 CR 005-283C. Mr. Durante O'Neill, and his probation case is revocation case is 23 PV 001275. Mr. Durante O'Neill was convicted of simple assault and criminal trespass, and this is a revocation matter. Mr. O'Neill, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean, who is at the courtroom 2 location. Do you see him? Courtroom 2. Do you see him?
Yeah, ma'am.
Yes? Okay. Ms. Harris, It's been about an hour, 45 minutes ago. Have I sworn you? Have I?
No, Your Honor.
All right. So do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. All right. And what's the recommendation for Mr. O'Neill?
Yes, Your Honor. The recommendation for Mr. O'Neill is to give him credit for the time he served as the closest case.
Right? Any objections, Mr. McLean?
I can't imagine Mr. O'Neill having an objection to that, although it could be possible. Mr. O'Neill, do you understand the recommendation? Your case will be closed and you're given credit for the time you have served, and then your case is over with. Is that okay with you?
Yes, sir.
It will be marked as a probation violation on your record, and the time that you've served at the jail is commuted to time served, and that completes your obligation for this case. Thank you.
Okay, this is final. I'll be right back. Give me out.
All right, sir. If you can mute the screen, that'll be appreciated. Thank you. I am still waiting on Mr. Howard. And Mr. McLean, your cases begin from position
14.
Okay.
Of
So Daniel Martin, you're still waiting to talk to him?
I need to convey the offer to him. The state did make an offer, and I'm going to convey that to him. It may be that I can talk to him on the phone if they can call that extension. And if that's inconvenient, I can run up to, he's on 3-1.
I saw Daniel Martin, but I cannot recall which panel he was at. Was it medical?
I can, if we take a break, I can run up to the floor that he's at, see him in a visitation booth, and then just come back.
Right now, I'm just waiting on probation matters, and so
Can we do
why don't you
probation
hang
one?
tight until 5 North brings the next probation case?
Can we do probation one?
Probation 1,
Probation number 1, Harris.
Harris. Yeah, we can. Is that the gentleman for? Is that Mr. Harris?
Yes.
All right. Mr. McLean, is that your client too?
Yes, Your Honor. Mr. Harris is a probation case, and we'll be glad.
Okay. Jarvis Harris is 21 CR 007-425B. This is a probation revocation matter. And Mr. Harris was convicted of criminal trespass and obstruction of a law enforcement officer. Ms. Harris, what is the recommendation for Mr. Jarvis Harris?
The recommendation for Mr. Jarvis will be credit for the time he served and to close his case.
And he tells me he has no objection, Your Honor.
All right, Mr. Harris, this will be marked as a probation violation on your record. This going to take the time that you've served at the jail and commute it to time served, and your obligation for this case is completed. Thank you.
Okay.
All right. All right, Mr. McLean, while we are waiting for a probation case or one of Mr. Howard's case to appear. So Daniel Martin, we are holding until you get a chance to talk to him. Position 15 was a waiver of arraignment and bond modified to $3,000 signature bond through pretrial. Position 14, Chestis Nixon is reset to October 12th for a possible plea. 17, Pena was a plea. 18, Javonte Hupp. Was he released?
Bonded out on October 6th.
All right, thank you. 19, Salazar Eberardo.
I have to go and get him as soon as I finish with the 2 females, Your Honor.
Okay, thank you. 20, Sanders was a plea. 21 was Sandberg was a waiver of arraignment.
I'm sorry, Your Honor, I was on mute. If I hold down the space bar, I'm unmuted. On Salazar, we're trying to get him into DUI court, but there's a felony charge in the way. I'm going to be speaking again with the felony attorney to see whether that's going to be possible. So really, there's nothing ready for Mr. Salazar today. We probably administratively would be better off just resetting that a week and seeing if that's going to be possible at all. We're
Can I
certainly,
reset him for October 17th?
that'll be fine.
All right. Deputy Milton? Deputy Milton?
Yes, Your Honor.
Mr. Salazar's case is reset to October 17th, pending more information to be obtained.
Thank you.
All right. As I was saying, position 20, Sanders was a plea, 21, Sandberg was a waiver of arraignment, same announcement for 22, waiver of arraignment. 23, Simmons was a plea. 24 was null pros as a result of the plea in 23. 25, Jonathan Smith is a plea. 26, Jeremy Thompson is a plea. 27, Deneen Walker is reset to October 17, pending a social worker's visit. And Mr. McLean still has to speak to our add-on, Daniel Martin.
If it's not convenient for Mr. Daniel Martin to call the 2392 phone, I'll just run up to, I'll look up his cell location and run up there and run back.
Mr. Jordan, could you please advise Mr. Howard? We are waiting on him to start addressing his cases.
It's on position 20. Was that terminating upon payment of fine, or was he supposed to be on probation the whole 12 months?
I think it was non-reporting.
Thank
you. All right. All right, so Mr. Howard, if he can be available, Mr. McLean's going to talk to Daniel Martin. And then I have my bench warrant, Mr. Pierre. It's Mr. Pierre Brewer. Please start your video. Pierre Brewer.
I'm about to get out of the room, Your Honor. Pierre Brewer is the DVVW case.
Yeah, is that your client too?
No, Your Honor, that's Mr. Howard. He did speak to him on the phone, and so that'll be Mr. Howard.
Okay. So Mr. Howard has the rest of the cases. Yes, 3 South. Who do we have?
This is position number 10 and 11 on probation.
Is that Mr. Howard's client?
Yes.
Okay. Mr. Howard? Oh.
Just a second, Judge. He's Mr. McLean's time, but I just need to give Mr. McLean a message about it.
You said you forgot your phone.
My phone. Oh, someone needs to mute.
Hello, this is Pierre Brewer. I'm sorry, ma'am.
That's okay. Number 1, you have to stop moving around. Number 2, you need to stay with your phone.
Yeah.
And mute yourself right now.
All right.
Okay.
Judge.
Yes, Mr. Howard?
All right, on camera, we have Mr. Michael Thompson.
Yeah. And Mr. Michael Thompson is got a probation revocation matter, 23 CR 67A. And then his probation revocation matter is 23 PV 1232. In the underlying case, he was convicted of battery family violence, and this is a probation revocation matter. Mr. Thompson, you have a right to remain silent. Anything you say in open court, your statement can and will be used against you. You have a right to an attorney, and Mr. Derek Howard will be representing you. Do you see? Oh, sorry.
Cut you off, but what we were gonna announce was there's something we need to confirm so that we can handle his matter. So we're asking that his case be reset to Thursday's probation calendar, and we should be able to hopefully get the confirmation of the information that will determine.
Understood. May I hear what Officer Harris's recommendation is? Officer Harris?
Yes, so our recommendation is gonna be revoke his remaining 4 months on probation.
Okay. So it's best if we reset it to, is it this Thursday or next Tuesday?
We would ask if we could do it this Thursday, Judge.
I have a really long probation revocation calendar this Thursday. Let me see. I'm already 8 cases over the limit. I can bring it to Tuesday, the 17th. There's plenty of spaces.
Okay, Judge, and let me, Tuesday, the 17th would be the day. Okay, and I do show.
17th.
He does have another felony probation matter. So yes, Tuesday, we can do that, Judge.
All right. Mr. Thompson, your case is going to be reset to October 17th, probation revocation calendar. And we will address it at that time. Thank you.
McLean, are you ready for Mr. Martin? Come on, Martin.
All right, Mr. McLean, he is at 3 South. You can either use Mr. Derek Howard's laptop if it's available, or you can sprint it to 3 South. Which would you like to do? What's the other option?
Breakout on the laptop would be great, Your Honor.
Okay, I think Mr. Derek Howard's back on the laptop. Okay. All right, Mr. Jordan, you see Mr. McLean pretending to be Derek Howard on the Zoom?
Yes, ma'am.
All right, can we place Mr. McLean and 3 South in a breakout room, please?
Okay.
Thank you. All right, Mr. Howard, we have quite a few cases on hold for you.
Oh, quite, which other cases we have on hold?
Let's start with ACDC. And I believe one of them is Miss Walker.
No, Your Honor, position 7, Ms. Ferris.
Oh, Miss Ferris, all right, okay. Tatiana Ferris. All right, Ms. Ferris, you've been advised of your rights. Your attorney is Mr. Derek Howard. This is position 7 on our SAP calendar, 21 CR 6633B. Mr. Howard, how are we proceeding with Ms. Ferris?
Judge, I've been waiting on a response, haven't gotten it, so in abundance of caution, we talked about resolving this. She has a court date on her Superior Court case, I believe it's next week. So out of abundance of caution, I'm gonna ask that this be reset until next Thursday so that we can confirm that there's no reason we shouldn't resolve this case. And since she's been held on that case anyway, she'll be here, till next week. I've been reaching out since yesterday, but I hadn't gotten an answer from the Superior Court attorney, and I do want to get that out of abundance of caution.
So
if it be okay, it'll be a negotiated plea.
for today or another day?
No, we're asking it to be reset to next Thursday so we can get confirmation.
Next Thursday, which would be
A week from today, right?
no, next Tuesday.
Oh, today's Tuesday, right? Next Tuesday, Judge. I'm sorry.
See, I'm not the only one confused. Okay.
You're the only one. My day.
All right, case is reset to October 17th. And Miss Ferris, I guess your attorney is going to look into your other open case and then guide you appropriately with regards to the current matter.
Yes.
Thank you.
All right. Next position, Deputy Milton.
Position 2, Marquita Brown.
Ms. Marquita Brown is 19 CR 1774G, accused of battery, family violence. Ms. Brown, you've been advised of your right to remain silent. Your attorney is Mr. Howard. And how are we proceeding, Mr. Howard?
Does this be a not guilty and a bond hearing for Ms. Brown?
All right. Do you waive a reading of the accusation?
We do, Judge. I'll submit a written waiver for it.
All right. Ms. Brown, your attorney is going to submit your not guilty plea pursuant to a waiver of arraignment. Just to reiterate that upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the prosecution would have to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the state prevails, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not
Guilty. Not guilty. All right. Anything else with regards to Ms. Brown, Mr. Howard?
Yes, Judge. Ms. Brown is a lifelong Georgia resident. She was born and raised here in the Metro Atlanta area, graduated from Fulton High School. She also attended West Fulton High School. She attended Atlanta Area Tech as a dentist under their dentistry program. She was actually working for a dentist as a side assistant for Dr. Farrell up until the time she got arrested on this. She does not have any minor children, but she does have the rest of her family lives here, her son, her uncle. And so she does have sufficient ties to the community, Judge. She vehemently denies this allegation. She tells me that this gentleman has actually assaulted her in a sensitive way in relation to this incident. And once the facts come out, we believe it'll be clear that she was actually the victim of a crime in this case and not actually the person who should be accused. So we're asking the court to take that into account and allow her to sign home bond in this case. And the bond is currently set at $1,500, which she hasn't been able to make. So we'd ask the court to consider converting this to a signature bond. And I'm sure she's been in custody. She's actually done a total of 51 days on this offense, Judge. When she was originally arrested back in 2019, she did 32 days. And then on this arrest, she's done 19 days. So she's done a significant amount of time, without being determined to be guilty on this offense. So we'd ask the court to consider converting it.
All right. Ms. Nimini?
Yes, Your Honor. The state is going to oppose the request for a signature bond. The defendant has a current open case for aggravated assault. To my understanding, she does have a hold out of Cobb County. In addition, some of her criminal history, she does have 15 cycles. We have an aggravated assault from 2014, which is the 15 SC 131887. And that's where the defendant was terminated from behavioral health treatment court. In addition, Your Honor, she does have a 2019 battery family violence case as well. And I think that's actually this case. And I just want to put on record, this incident happened when officers arrived at the location around 2 a.m. They spoke with the victim, Mr. Keith Byron, who stated that his girlfriend, the defendant, locked him outside of the home and threw his belongings outside of the home. He advised officers that she possibly had MH issues and was trying to kick him out of the apartment, but both parties reside at that location and his name was on the lease. The officer observed the clothes and the items on the ground. Once the officer were able to make contact with the defendant, she claimed that there was a new lease and she didn't want him living there with her 19-year-old son. The officers advised them that because Mr. Byron was currently on the lease, she could not kick him out unless he was actively evicted. She made comments about her paying for all the food and the TV and the furniture, and the officers told them like he had the tenant's right. Later that day, officers were called again by the same victim who stated that he was locked out again. And when he arrived, he advised officers that she had bit him. He was sitting in the living room. She went over there yelling and attempting to punch him in the head and ended up biting him in the location observed by the officers. I think it was, Officer observed a bite mark on his upper right back resembling a red and purple bite mark. When officers asked the defendant how the victim got that bite, she said he may have bit himself. And it was not possible for the victim to bite himself, Your Honor, considering that she does have an ag assault hold out of Fulton County and this issue with battery family violence, Your Honor, and I think a couple failure to appears, 5 failure to appears, Your Honor. The state does believe the 1,500 surety bond is more than reasonable, Your Honor.
When's the last FTA?
In 2023, this
Okay.
year, there's 2.
Oh, for this case,
Yes, and then a 2022 as well.
for the Cobb County matter.
Yes, Your Honor.
Okay. Anything else, Mr. Howard?
Another president.
All right. I'm going to grant a $5,000 signature bond through pretrial. She's going to be released on a signature bond through pretrial. And I just want to confirm whether the old Atlanta station is her current address or has she moved again?
No, the 3997, yes, that's the current address, Judge.
Current address, all right. Ms. Brown, you're going to be released on a signature bond, but you're reporting to pretrial once a month. You need to make sure our address is current at all times. And if you miss another court date, that will be one too many misses, and you just end up spending the rest of the time in jail awaiting trial.
Every month, I will. I know what pretrial is.
That's good. No further contact with Keith Byron, no alcohol, no drugs, and no weapons. Thank you.
Thank you, Judge. You got it?
Yeah, the battery went dead.
And the state does,
Bye, Your Honor. Bye,
Thank you,
everybody.
Deputy Milton. Take care. Okay, before I move on to, and yes, I'm sorry, Ms. Nimini, you were saying?
the state does revoke their plea recommendations, Your Honor.
All right, thank you. Mr. McLean, we're going to address your client, Mr. Martin. I just had a question. Somebody was asking about to whom documents are sent to someone. Mr. Jordan, were you able to answer this person's questions? V.V. Williams.
Your Honor, I did provide my email address. I was assuming that the individual was asking about documentation showing that the defendant was previously incarcerated.
Okay.
I might be wrong.
I don't know. I'm just hoping somebody responded to that chat. Okay. Mr. McLean, ready for Mr. Martin?
Your Honor, let's see, am I on mute? Okay. Your Honor, we did have the battery go dead and we're charging it back up on the laptop. So, Mr. Martin, did you have another question for me, or was that, did you understand the incomplete conveying of the offer?
I understood what you were saying, but yes, I understood.
Okay. Well, so did you want to go forward with that today or not?
Yes.
Okay. We're ready, Your Honor.
All right. This is State versus Daniel Martin, case number 23CR5279B, accused of disorderly conduct and simple assault family violence from November 16, 2022. Mr. Martin has an add-on case as well. And if I just get to that page, and that would be 23CR5933B, in which he's accused of simple battery family violence, criminal trespass, and obstruction of or hindering a person from making an emergency phone call. And this is from July 26, 2023. No, I'm sorry, it's July 20th, 2023. So these are two active cases against Daniel Martin. Mr. Martin, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Mr. McLean, how are we proceeding?
Your Honor, it turns out there are a total of 4 cases. I believe the state has the handy, the case numbers.
Yes, Your
And
Honor.
what we're going to do is a 3-year probation in all the cases. And I'm going to argue the one element that will be not negotiated is whether or not 12 anger management will suffice in the stead of family violence intervention program.
All right. So Ms. Bodie, look, I've got the 2 cases I've just mentioned. What are the other 2?
Yes, Your Honor, we have a battery family violence taking place January 9th of 2023. That case number is 23 CR 002586B.
Okay,
And then we also have a simple assault family violence that took place on November 4th of 2022. That is case number 23 CR 005276B.
right, and then the November 16, 2022 incident, and so we have a November 4th, 2022 incident, November 16th, 2022 incident, January 9th, 2023 incident, and a July 2023 incident.
Yes, Your Honor.
All right. Mr. Martin, I'm going to consider this a non-negotiated plea since not all the elements have been agreed to. What that means is that the prosecution is going to give me their recommendation for a sentence if you decide to plead guilty. And then your attorney is going to tell me what are the distinctions or the differences that they're seeking. And then I will let you know which recommendation I'm going to accept. Understood? All right, Ms. Boddy?
Yes, Your Honor. So again, as you heard, the total for all 4 cases will be 36 months probation, served 365 days, credit for time served 156 days, balance probated to stay away from 6354 Shannon Parkway, Unit 7F.
I'm sorry, I'm going to stop you for a moment. 3 South, could we please mute? Thank you. Stay away from 6354
Shannon Parkway.
Shannon Parkway, okay.
Unit 7F in Union City, Georgia.
Mm-hmm.
And no further contact with Sarah Jean Mosley. Family Violence Intervention Program, 40 hours of community service, and a third-party transfer of any children that they share. I can break that down.
Mostly, okay.
Yes, ma'am. I can give you a breakdown on each case in reference to the 23 CR 005279B, the disorderly conduct and simple assault family violence. The recommendation is 365 days in jail, credit for time served 156 days on count 1 being the disorderly conduct. For the simple assault family violence, count 2, 365 days, credit for time served 156 days, and that will run concurrent to count 1.
Okay, so this is a global offer for the 4 cases.
Yes.
It's a consecutive sentence. Which case will be a concurrent?
It's my understanding.
If you've got 36 months, so that's 3 years.
1 second, Your Honor.
Oh, he's already served time on one of them.
I believe it's going to be CR 5933B, if I'm not mistaken.
CR 59. That would be the latest one, the add-on?
Yes, sir.
Your Honor, I sent the breakdown to Mr. Jordan and Miss Grace. If you would like, I can send the breakdown to you as well.
Okay, please do. But I just wanted to clarify for the record. So the 365 with the 156 days, that he would have completed the jail time for that case. And then the other 3 cases with the global offer, is going to be to serve 365 days on probation consecutive.
Your Honor, and I can send the breakdown. Case number 14 is the 365 days in jail, credit for time served 156. That would be a time served, as well as the simple assault 23 CR 005276B. So those are both time served closeout. The 2 that would remain open and run consecutive are 23 CR 005933B and 23 CR 002586B, which are his 2 most recent cases.
Consecutive?
That is correct.
And then 27. 3-3, that's consecutive, that's the latest one.
That is correct.
So, but you said 36 months, isn't that 3 years?
Yes, how that's going to work is on the simple battery on the 23 CR 005933B. It's going to be 365 days. Credit for time served 156. The criminal trespass will run consecutive to count 1. And then on the second case, that 2586B, the 12 months will run consecutive to 23 CR 005933B. So that's how we get the 36 months and then credit for time served, the 156 days against that 365-day sentence. So that will leave him with 2 years left on probation.
Okay. All right, please give me that breakdown because I'm not going to be able to rattle all that off.
Now, apparently, Your Honor, I think it's basically, we're unnegotiated on whether it would be the FVIP or the 12 AM. However, let me point out some math here. 156 days would take us back to last spring. That would be something like March. This is October. If his arrest was in July, and if he has 5 days of July jail time from the East Point or the College Park jail on the same case, he would be getting credit for that. I'll talk to the record room about that. But if the record room has a July arrest, they're going to be calculating this at something like 78. 78 is half of 156. I don't know if a math error has been made in terms of doubling the 78 to get the 156, but the record room not honoring it because he physically has not spent 156 days.
Your Honor, and Mr. McLean is correct. That is an error on my part. My apologies. It is 78 days.
So to get about 20, if the goal here is to get about 20 extra days of jail, then let me do some calculations real quick. Would it be 218 instead of 365?
I'm really thrown off by to which you're applying the time served and which you're applying the consecutive because of the age of the cases. And then tell me another thing is why anger management versus FVIP, since we have, just one violent case after another with regards to Mr. Martin.
Understood, Your Honor, but he's going to be working in a warehouse and he won't have a great deal of income after paying these. He's going to be on probation for 2 years. And that'll be 24 months. That's going to run him $1,200. FVIP costs $35 to $40 a class at the very.
But it's only for 24 weeks. It's not, doesn't run for 3 years.
True, but it costs $840 to $960 for the cost of the class alone. And he is going to have to get out and get a job. And at his age, he's concerned about being able to get a job at the warehouse. And so when you're paying $49 a month plus $35 or $40 a week, that adds up to over something like $200 a month. It's going to be financially a great hardship. I think in 12 weeks of anger management, he will glean a fair amount of content from that kind of course. But
Your Honor, if I may.
The inflation on the other thing, I think works out to something like to cause him to spend an extra 20 days in jail would roughly be about 218 days, but I could try to figure that out. We would take 78, double it to 156, add 20, that's 176. And then
Wait, before we get into the math, let's talk about the FVIP. Yes, Ms. Boddy, what is the state pushing the FVIP as opposed to anger management?
Your Honor, in all 4 of these cases, we have the same victim, Mrs. Sarah Jean Mosley. And so it would be our position that in an abundance of caution and advocating for her safety, that these classes are taken. These are all violent offenses, these cases, and she is the victim in each of these.
All right. Mr. McLean, I agree with the state. I'm not certain what's going on between Mr. Martin and Ms. Mosley, but clearly he doesn't qualify for mere anger management classes. This is a gentleman who needs to be in some intense domestic violence programming. counseling classes.
Mr. Martin understood the court would make a decision on that issue, Your Honor.
All right. The next thing is all this 2-for-1. If he is going to be on probation, I don't know why I have to count for 2-for-1 in this particular matter. If he served 156 days, I'm going to keep it 156 days and put him on probation for 3.5 years.
He's physically been in jail for, I believe, the 78 plus the other 5 or 6 days that he was in the East Point jail, and that would be 78 plus 5 would be 83.
Okay, give him credit for 83 days and he'll be on probation for the remainder of the time if the state's willing to release him.
Your Honor, given that it's 4 cases, the state's not willing to come down on the 365 days in jail. If he wants to go to the jail jury calendar, as he's done on his other 3 cases, he's welcome to do so. But these are 4 cases against the same.
I know, and
State's not willing to come down on that jail.
Okay.
If it's 365, they do that as 366. And they come off with 183, and if they only have, that's going to be 100 extra days in jail. That's going to be over 3 months more in jail.
For 4 cases, all separate, same victim.
That's a bit much.
What would your client like to do?
I don't think he wants to spend another 3.5 months in jail and then go on 2 years of probation. Am I correct, Mr. Martin? What is your notion?
I really would like to talk to you about this situation, but I want it to be known that during this time.
He would like to talk to me about it.
Okay.
I would like to say this.
Thursday, Tuesday, the 17th, and I'll be sure to talk with him.
I would like it to be known.
Mr. Martin, I would not recommend you make any statements about your case or about the victim in this particular matter, because these are very serious open cases against you, and anything you choose to say may convince the prosecution or the court to not accept any plea offer.
Your Honor, I understand that, but I want it to be known that we were going.
Mr. Martin, let's not. Mr. Martin, you and I will talk during the next week. Mr. Martin, please. You and I will talk during the next week, and you and I will decide what else needs to be let know. Okay? Thank you.
This case is reset to October 19th at 9 a.m. At that time, let's get a more concise plea offer in terms of which cases is he going to be serving probation, and to which is the time served going to be applied? Because at this present time, I am totally confused by the numbers. All right, October 19th at 9 a.m. Yes, Mr. Jordan?
Before everybody goes. So I was looking at Mr. Martin's cases. He is currently in jail on the case that's on the add-on counter for 78 days. Case ending in 2586B, he only spent 5 days in jail, and I can't find the time he spent in jail on the other 2 cases. So any additional time to serve placed on those cases means he's going to spend that time in the Fulton County jail. They're only going to give him 78 days credit on case 5933B.
I think Mr. McLean referenced some other location where he served time. So, like I said, I'm confused. So we just need to tighten up on the numbers.
Right, they're gonna have to provide all that documentation to jail records in order to get that credit, or he's just gonna sit in jail even longer.
Okay. Yeah, that was just 5 days East Point. That's not the main point. The main point was whether he would serve an extra 100 days under the 365. Okay.
All right, thank you. Position 14 and the add-on are reset to October 19th, and that's a Thursday, by the way, folks. Thank you.
Position number probation 2 and 3, Ms. House.
Okay, thank you. This is Brandy House at 5 North. And then after that, Mr. Howard, we're going to go to Mr. Redding at Norman Gibson.
Okay.
Brandy House is 22 CR 007-683C. And the probation violation matter is 23 PV 1274. In the underlying case, Mr. House was convicted of battery of a sensitive nature. And Ms. Harris, and it looks like his probation may be revoked. What is the state's recommendation?
Our recommendation was give him credit for the time he served and to close his case, Your Honor.
All right. And
Ask the court to follow that recommendation, Judge.
all right. This is going to be based on probation's recommendation that the time that he served is commuted and that the case is closed. This will be marked as a probation violation on his record. Thank you.
Okay, so
All right, Mr. Redding at Norman Gibson's panel.
Yes, ma'am.
All right. Mr. Howard, is that on the SAP calendar?
It's a probation matter as well, Judge.
Okay. All right, this is position 6 and 7 on the probation calendar. Mr. Charles Redding is got a probation revocation in 23 CR 966F, and the probation matter is referenced as 23 PV 1277. In the underlying case, Mr. Redding had been found guilty of simple battery family violence. Ms. Harris, Officer Harris, what is the state's recommendation?
yes, Your Honor, after speaking with Mr. Howard, probation recommendation is give credit for the time he served and to close his case.
Is that correct, Mr. Howard?
That is correct, Judge.
All right. Mr. Redding, the probation is also going to give you credit for the time you've already served. That's commuted, and your obligations for this case is concluded. Thank you.
What that mean, like, it's
That
closed?
means you don't have to report to probation. This case is closed. You've served your time to society, and you don't have any other obligations for this case.
So that mean I go home?
Do you have any other cases holding you at the jail?
Well, you got to deal with the other matter, Mr. Redding, but you're done with this case.
Yes, ma'am. Thank you.
All right, thank you.
Thanks very much. God bless you.
You too, sir. Take care.
I'm finished.
Can we do probation, Mr. White, probation 12 and 13?
Yes, please.
All right, I'm ready. You're ready to walk. Are you ready? That's why I work at different.
We also have Mr. Andrew Teofilo.
He's at a different location. I haven't reached him yet. So
Okay, all right. So right now we have positions 12 and 13, Pelarius White. The probation revocation is in case 22 CR 8472B, and the probation matter is referenced as 23 PV 1273. Mr. White was convicted of simple battery family violence. Mr. White, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. Your attorney is Mr. Derek Howard. Officer Harris, what's the recommendation for Mr. White? Are you on mute, Officer Harris?
Sorry about that. After speaking to Mr. Howard, probation recommendation is to continue him on probation to change the domestic violence classes to 12 weeks of anger management.
And we'd ask the court to follow that recommendation, Judge.
All right, and when's his first report date? Would it be on Monday? No, will be on Friday, correct?
He does have a Superior Court matter, Judge, so he won't be released right away.
Okay. Does the state understand that he won't be reporting within after 48 hours?
Yes, Your Honor, we understand that.
Okay. Mr. White, the recommendation is for you to continue on probation and complete your obligations for this sentence. And it also requires you to complete 12 weeks of anger management classes to begin within 30 days of being released. Is that something that you're willing to accept?
Correct,
All right. Then that will be the sentence on the revocation matter. It will be marked as a probation violation. And once you are released, you must report to probation within 48 hours, the immediate next business day after 48 hours to probation. And like I said, you will need to begin your 12 weeks of anger management classes within 30 days of being released. Thank you.
And Judge, since he is being continued, I don't believe it would be a violation, correct? Since he's been continued.
Yes, it will still be marked as a violation. All right, next case. I think the only thing we are waiting on probation is positions 8 and 9, Mr. Teofilo.
And
Give me a moment, let me go to 3 North, give me a moment.
also, if you'll call 2392 or, once you get him, because I know you had some concerns about his DBA.
All right, is there anyone else who is represented by Mr. Derek Howard who has not been addressed? Otherwise, I'm going to.
Yes.
Yes, I know. As I said, otherwise I'm going to Pierre Brewer, who is our bench warrant matter. And Mr. Brewer, please start your video. All right, again, you need to stop moving around.
Yeah, I'm sitting down now.
Okay, this is case 22 CR 004-193A, State versus Pierre Brewer. Mr. Brewer was accused of simple battery family violence and simple assault family violence from an April 18th, 2022 incident. It appears that Mr. Brewer failed to appear in court on March 3rd, 2023, and a bench warrant was issued on March 7, 2023. All right, Mr. Brewer has filed a motion to set aside the bench warrant. Mr. Brewer, you have a right to remain silent. Anything you say about this case in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. Derek Howard is representing you. Mr. Howard?
And actually, Judge, Mr. Brewer, Mr. Brewer, I didn't get the return application. Did you send it back?
Yeah, I tried to do it through the PDF and it kicked me out my phone. And by the time you sent it to me, everything was closed. But I can have it done by the end of the day.
So Judge, he'll be proceeding, say, I think he has a handle on the issues.
Okay. So he's representing himself?
Yes.
All right, Mr. Howard, could we mute? Like, I think you have another device on, is creating a feedback. Thank you. All right, let's go ahead and mute your laptop and courtroom 2, or one of them, please. Thank you. Thank you. All right, Mr. Brewer, you were originally represented by Mr. Howard, but it appears that you are now choosing to represent yourself.
No, he was never represented by his judge. We asked him to send an application, and I sent him the application. He didn't return it, so right. He was never represented.
I couldn't return it because by the time you sent it to me, everything was closed. You called me like
digital. You can do it online. Remember, we talked about it.
Let's switch off the laptop and speak through the courtroom. It's still creating a sound back. Okay, so let me get this straight. Mr. Brewer applied for the public defender's office. The application has not been received. So technically, he's not represented by the public defender's office. All right. Question number 1. When was the application emailed or sent to the public defender's office?
I didn't send it because I couldn't fill it out. By the time he sent it to me, ma'am, it was almost 6 o'clock in the evening. I had no.
What evening? Which one?
Yesterday, ma'am.
Your court date is until 11 a.m. I don't understand why it couldn't have been filled out.
I tried to do it, man, through the PDF file, like he told me to do it, and I didn't
Did
get
you
understand.
did you print it and then fill it out, scan it and send it back?
No, because he told me to do it through the PDF file.
Or print it out if you can't do that and send it in. So I gave you both instructions, sir.
All right. Mr. Brewer, you did not submit the application on time.
All right.
This is still a bench warrant against you. You can surrender yourself at the jail and then bond out. I'm not sure what bond judge.
I have posted my bond. The reason why I couldn't make it to the court date because I was incarcerated in Lake County Jail. When I got transported from White Street, which was June 28th of 2022, I've been incarcerated in Lake County Jail since June of 28th of 2022, all the way up to September 22nd of 2023. So when the courts issued me a court date, my county sent an email to White Street asking them was they gonna come and get me for the court date. But White Street denied it because of the far and how much length it is, because I'm from up north to Illinois area. And they said that would be pointless to come down there and get me just to bring me right back to that county because I was serving time in Lake County Jail.
Thank you. Mr. Scirocco, are you prosecuting this matter?
Yes, Your Honor.
I've got a letter from Superior Court of Lake County in Indiana. Have you seen that document? It's on Odyssey.
It's been reviewed, Your Honor. It does appear that he was in jail in Lake County, Indiana, at the time of service. We're not objecting to the lifting of the bench warrant and resetting the case. However, the bond was returned to the bail bondsman. So there's no bail at all in this case. And so the state at this time would like to request a signature bond through PTS. And regarding the facts of this case, just to give you a bit of context, the victim here, Miss Raejean Young, Raejean Young, traditional spelling. The victim was at home at 4555 182F Washington Road with her newborn baby, of whom the defendant is the father. The defendant stated over the phone that he was coming over to see the baby and pick up his dog. Upon the defendant's arrival, he attempted to release the dog from the back porch. After the rear door had been closed, the defendant struck Miss Young. Though there was no verbal dispute leading up to the attack, Miss Young stated that she had previously discovered his criminal history and wanted to discontinue his presence with her and her daughter's life until matters were resolved legally. In addition to that, Your Honor, with that context, we would request a stay away from 4555 182F Washington Road, as well as a no further contact with the victim, Miss Raejean Young, Raejean Young.
All right. Mr. Brewer?
Yes, ma'am.
Since he's already actually, I'm going to set aside the bench warrant.
What do you mean by setting aside, ma'am? Taking it off me?
Yes.
Okay.
On grounds that you have proven that you were incarcerated at the time of the court date with Judge Roth.
Understandable.
All right.
Yes, ma'am.
Looks like the bond has already been surrendered back to the bonding company. So I'm going to amend the bond. On the simple battery, it's going to be $2,000. On the simple assaults, $2,000. It's going to be a $4,000 signature bond through the jail.
All right.
You are to have no contact with Raejean Young.
Yes, ma'am.
I was the one who set your original bond back in, my goodness, June of 2022. Okay, so the same conditions are going to apply. No contact with Miss Young. You cannot return to 4555, what I think is Washington
Road.
Yeah. If you and Miss Young share any children, And if you want to have visitation or custody with the child, you need to file for a legitimation action. All
Okay.
right? You need a
Okay.
Superior Court order to
How do I go
establish
about- how do I
visitation and
go about-
custody.
How do I go about filing the legitimate action?
You can go to the Family Center at the Fulton County Superior Court if that's the appropriate jurisdiction.
Okay. All right. Thank you, ma'am.
All right. The other thing you need to do is make sure that we have a current working mailing address for you.
All right. And
So
when will
you
be my
need to come down to the clerk's office at J150 at 160 Prior Street and fill out
said-
and confirm your mailing address.
Okay. Okay.
Okay, any questions? The order, I'll draft the order and issue that today. If you
You said-
violate the conditions, the next
You-
time we have a bench warrant, you just have to surrender yourself. You don't have to worry
All right,
about
that's
it.
That's understandable, ma'am.
All right, thank you.
Thank you.
3 South, who do we have, please? Why do I have a Weavy Williams? Who is this Weavy Williams?
This is
Oh, that's my
probation,
fiance. That's my
probation.
fiance. She.
Okay, she wants to start her video. Please, and unmute.
She trying to.
I'm sorry, I'm on here. I just was trying to
Who is Snapfinger Wood? Who lives at Snapfinger Woods?
I put the address. That's for
That
Pierre
would be my
Brewer.
address.
All right, he's going to come down to the courthouse.
Okay.
And file that in person, in writing.
Okay.
All right.
Okay.
Do not interfere in a court proceeding with your chat, or I
Okay, I
am going to
apologize.
find you in contempt. Understood?
Yes, I'm gone.
Thank you. You're gone.
Understand.
Good. Toodles. Toodles.
All right. All right.
All right. 3 South. Who do we have?
Probation's 8 and 9.
All right, Mr. Teofilo? Okay. Sorry, I have to switch windows over here. Okay, there we go. Probation revocation, position 8 and 9. This is Andrew Teofilo, case number 22 CR 006178J. He's got a probation revocation matter that's referenced as 23 PV 1276. Mr. Teofilo, my name is Judge Lal. I'd like to remind you that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Derek Howard. You were convicted of theft by taking, and this is a revocation matter with the sentence you received. Officer Harris, what is the state's recommendation?
Yes, Your Honor, probation recommendation is give him credit for the time he served and to close his case.
All right, Mr. Howard, this will be marked as a violation. Any other objections?
If they get
Oops. I think if you switch off courtroom, and switch on courtroom 2.
They could just unmute Mr.
Yes, sir.
Teofilo and make sure he's fine with that.
All right, Mr. Teofilo, the state is recommending that the time that you've served be added, to be commuted. In other words, your obligations for any further jail time is over. You have no further obligations in the case, and your case is closed, although it will be marked as a probation violation on your record. Do you have any objection?
No, Your Honor.
All right.
No, Your Honor.
All right, that will be the sentence, and that concludes this cases. Thank you. I think that concludes, thank you. I think that concludes all the revocation cases we have. So Mr. Howard, do you have any other cases left? I see someone at 5 North.
Yeah, position number 1, Mr. Bailey.
All right, that is Mr. Derek Howard. Mr. Howard, this is Edward Bailey, charged with battery family violence from September 21st, 2023. Case number 23 CR 5710C.
Judge,
And how are we proceeding with Mr. Bailey?
yeah, before, I do need to speak with him. He was not locatable yesterday, so I do need a few minutes with him.
Do you have any other clients? I don't think that, I think that was your last one, right?
It should be the last one, Judge.
All right.
But I had-
Miss Grace or Mr. Jordan, can we place courtroom 2 and 5 North in a breakout, please?
Yes, ma'am.
Thank you. All right, we'll be in recess until Mr. Howard's ready. 5 North, you're going to see a message on your screen to join a breakout. Officer Harris, I think you're done. Yes?
Yes, I was just about to ask, can I be excused?
Yes, you may. Just make sure the documents are sent to Miss Grace or Mr. Jordan. I think it's Mr.
Okay.
Jordan today.
Yes, Sean, thank you.
Okay. He drew the short straw, so he gets to do this today. All right. Thank you, folks. Anyone else who's not involved in this case are free to go. Thank you.
You just sit right, man.
All right, Mr. Howard. Are we proceeding on Mr. Bailey?
Yes, ma'am.
I'm sorry, Mr. Bailey, Mr. Howard? Yes, sir. How are we proceeding?
Judge, Mr. Bailey will be a plea. I do need to, I guess, make the state aware that we're asking that it be done as a nolo contingent plea as opposed to a guilty plea. And I don't know if that would make it non-negotiated. But outside of that, the only other thing, we do have a question about the contact and if in fact the victim in the case, Alexis Nailing, has been contacted. If they do have a child, or they may need to have contact. So we wanted to see if there's a way to facilitate some type of contact between the parties.
All right, Ms. Nemini, there is a request for a nolo contendere plea and to clarify contact with the victim and the child.
Considering we don't have any information with contact with Ms. Nailing, we are going to push for no further contact. In addition, I would need a couple of minutes to double check for the nolo request.
Okay.
Yes, ma'am. Yes. Wow.
And is Ms. Tyson, do we have any prize on Mr. Bailey?
Yes, Your Honor. He took he has a 2020 simple battery out of Bainbridge that he took a nolo plea on.
Oh.
Let's see. He has another misdemeanor conviction out of Early County for driving while license suspended. That was in 2019. He has a theft by taking out of Bainbridge that he took a nolo plea on in 2017. We have another misdemeanor, willful obstruction in 2016 out of Bainbridge.
No.
We have another willful obstruction that he took a nolo plea on. 2 counts of willful obstruction that he took a nolo plea on in 2017 out of Cobb County.
That's good. Thank you.
Yeah, so the state is going to decline on the nolo, the wish for nolo. And we also have information that the state was able to meet with the victim. They've been together for 3 years. She's 6 months pregnant with a child. They do have domestic violence history. The state is going to oppose to no further contact with the victim. We will ask for a third-party transfer of the child, Your Honor.
You mean the victim does not want contact?
Yes, Your Honor.
Okay. Mr. Howard?
Yeah, road one.
And Judge, we understand that. I guess I'm wondering that there's no way to know this, I guess, right now, but if she could or he could contact when the child is born to get notice that the child was born.
I'll allow for a legitimation action.
Okay, gotcha, Judge.
And it's going to have to be a guilty plea or a trial?
Okay, we did discuss that option, Judge, so he still wants to proceed even if it has to be a guilty plea.
All right. If you could mute courtroom 2, Mr. Howard, I noticed somebody else is talking on the phone, maybe.
Yes.
Okay. All right, this is State versus Edward Bailey, 23 CR 5710C. Mr. Bailey, you've been advised of your right to remain silent, and your attorney is Mr. Derek Howard. You were accused of battery, family violence with regards to Alexis Nailing from September 21st, 2023. This is going to be a plea hearing, and the recommendation is that you enter a guilty plea to this charge in exchange for probation, no contact with the victim, and that you need to file a legitimation action in order to secure custody and visitation with the child or children that you have with Ms. Nailing. Are you ready to proceed with this matter?
Yes, ma'am.
All right, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. May I place your hand down? And Ms. Nemini, in addition to the no contact and the legitimation, what else is the state asking?
Yes, Your Honor. The state is asking for 12 months to serve 38 days, credit for time served 19 days, balance probated, an FVIP course, 40 hours of community service. In addition, with the no further contact with Miss Alexis Nailing, there won't be a stay away considering that the victim has moved from that location, but she did not provide us her address. So we just want to stress the no further contact with Miss Nailing, Your Honor.
Okay, thank you. Mr. Howard, does your, I've already verified that your client's willing to accept the term. Do you confirm that? And do you stipulate to the factual basis, venue, and ID?
Yes, we confirm that and we do so stipulate, Judge.
All right. Mr. Bailey, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you or inducing you to take this plea today?
No, ma'am.
And has it been explained to you that if you enter a guilty plea to this charge today, any subsequent arrest for battery, family violence will automatically be a felony charge?
Yes, ma'am.
Are you still willing to proceed willingly and knowingly?
Yes, ma'am.
If you decide to enter this plea, you would have to give up your constitutional right to a trial before a judge or a jury, to be able to confront your accuser, challenge the evidence and the witnesses brought before you, present any defenses and mitigating factors if you choose to do so, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes.
How do you plead to one count of battery, family violence?
Yes.
Your sentence is 12 months to serve 38 days, credit for time served 19 days. If you have no other cases holding you at the jail, then you will be released within 24 hours. You must report to the probation office next Tuesday at 132 Mitchell Street in downtown Atlanta before 3 p.m. When you report, you'll be placed on probation, where you would need to complete a 24-week domestic violence program, which must begin within 60 days of being released. You're also to complete 40 hours of voluntary community service at any nonprofit agency, which is not a school and not a church. You are to have no contact with Alexis Nailing. You're to stay 200 yards away from Miss Nailing, whether it's a workplace, a home, whether she's standing on a sidewalk. The distance you must keep is 200 yards away from her and not communicate with her in any way, form, or manner. If you want to establish contact with any child or children that you share with Miss Nailing, you must file a legitimation action in the appropriate superior court, and then you can have contact with Miss Nailing only in the form of mail with regards to that legitimation case only. Thank you.
Thank you, Judge.
All right, Mr. Howard, I'll just go over the cases that you had. Position 1 was a plea. Position 2 was arraigned and further notice for jail jury, $5,000 signature bond pretrial. Position 3 and 4, Bryant Butts, and 5 are all reset to October 12th. Position 6, Jericho Calloway. We didn't address that.
Yes, Judge, that's gonna be not guilty. We said jail jury. We told them not to bring him. We're gonna do a waiver.
All right. So please file a waiver of arraignment.
Yes.
Thank you. Position 7 is reset October 17th. Position 8 has been that's been a waiver of arraignment, and bond has been modified to $5,000 signature bond through pretrial. Position 9 and 10 were null pros. That was Miss Johnson. Position 11, Jones is that's Aretha Jones. Both the cases are a waiver of arraignment, bond established at $5,000 signature bond through pretrial. Position 13, Jermaine Jones was a plea. And position 14, Daniel Martin is reset to October 19th, along with the add-on position. And I've gone over Mr. McLean with his cases.
Okay, thank you,
All
Judge.
right. Okay, folks, that concludes our calendars for today. And we will resume at 2 o'clock for the C calendar. Thank you.
Thank you.
Bye-bye.